video, we'll be tackling some practice questions together that cover portions of the rules that we've already covered in our course. We will approach these questions in the same way we've handled our other practice questions. So turning to question 1. The facts state an attorney represented a telephone company in a suit against a customer for an unpaid telephone bill. The customer was not represented by an attorney. Soon after filing a formal lawsuit, the attorney contacted the customer and asked the customer if the customer wanted to engage in settlement discussions. The attorney stated that otherwise his client instructed him to litigate the lawsuit against the customer. The attorney told the customer that he wants what is best for everyone, including you, and that the settlement could accomplish that goal. The attorney and the customer agreed to a fair settlement agreement. Is the attorney subject to discipline? Let's articulate the rule being tested. This is a situation where you have a lawyer who's representing a party, specifically here it's the telephone company, who is speaking on behalf of that represented client to someone who is unrepresented. So what do the rules say about a situation like this? Well, the rules specifically tell us that in dealing on behalf of a client with a person that is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. To reflect upon the policy behind the question, I think this makes sense. You're being paid to represent someone. It should be abundantly clear to the other person that you're speaking to, who you represent, and whose best interests you have in mind. So knowing that, let's think back to what our facts state. Here the facts provide us some quoted language. Specifically, the lawyer told this unrepresented party that he wants what's best for everyone, including you, referring to that unrepresented party. This is problematic. The lawyer does not appear to clearly communicate that he only has his client's best interests in mind. In fact, the lawyer appears rather disinterested when he says he wants what's best for everyone. So because of this, the lawyer has violated the rule. So let's remind ourselves about what the call of the question states. It says, is the attorney subject to discipline? And we've determined that the lawyer has violated the rule, so the answer is yes, because the lawyer acted disinterested by virtue of his statement to the unrepresented opposing party. So evaluating your choices, starting with A. A says yes, because the attorney is not permitted to talk to an unrepresented party. Well, this is kind of silly, because if you're representing a client who's suing someone or has an issue against someone else who is not represented, how do you move forward with that matter? Of course you can talk to someone that's unrepresented. You just have to be careful with how you speak to them and specifically what you say. So A is wrong. B says yes, because the attorney implied he was disinterested in the matter. This answer looks good. It is a good resuscitation of the rule. It touches upon exactly what the problem is. So I think B is the correct answer. But let's review the rest of those answer choices to be sure. C says yes, because the attorney did not advise the customer to get a lawyer. Well, answer choice C is wrong because a lawyer does not have to tell someone who's not represented by a lawyer to go get a lawyer. You should do that when the person you're speaking to is confused about your role or wants information about how to talk to someone who has their best interests in mind. But it's not an automatic requirement that a lawyer has to tell a non-represented party that they have to get a lawyer or that they should get a lawyer. So this is not a requirement, and therefore answer choice C is wrong. D says no, since the attorney was being truthful and non-deceptive. D is wrong because maybe this lawyer is being truthful, potentially, but this is a little deceptive because he really doesn't want what's best for everyone. He should want what's best for his client. Additionally, truthful and non-deceptive is the wrong standard. This is not what the rule says. Instead, B talks about the rule, which is exactly the correct answer, making B the correct answer. Question 2. The facts state, an attorney agreed to represent a client in a lawsuit against a hospital. The attorney used a retainer form that he had printed from the internet, which stated the form could be used for any personal or commercial use. The attorney's agreement with the client provides in part. The client agrees to pay the attorney's fee for services within 30 days after receipt of the attorney's bill. Further, the client agrees to release the attorney from all liability arising from the representation. The attorney told the client that the client should consult an independent lawyer prior to signing the agreement. However, the client decided not to do so and signed the agreement without consulting a lawyer. Is the attorney's retainer agreement with the client proper? So here the rule that's being tested by the question is a lawyer's ability to try to limit his or her malpractice liability. And how do I know that? Because the question gives us quoted language, and the second sentence of it specifically states the client agrees to release the attorney from all liability arising from the representation. So more specifically, this lawyer is trying to prospectively limit his or her malpractice liability. And the rules speak very clearly to this issue. The rule states a lawyer must not prospectively make an agreement limiting the lawyer's ability to a client for malpractice unless the client is independently represented in making the agreement. In other words, the client has to be represented by another lawyer in signing this agreement. If the client is not independently represented, then this agreement cannot be proper. Here we are specifically told that while the attorney recommended the client receive independent advice from a different lawyer, the client didn't do that. The client wasn't told that they had to do that. Instead, it was just a recommendation. And when they didn't take that recommendation, the client then entered into this agreement with the lawyer. And the lawyer moved forward with it. The lawyer was fine with it. And that's a problem. The call of the question asks, is the attorney's retainer agreement with the client proper? And based on our discussion of the rule, the answer to this question is no, because the only way he could really limit this type of liability is if the client had been represented by another lawyer. So let's evaluate our answer choices. A says yes, because the attorney advised the client to consult with independent counsel prior to signing the agreement. A is a great trap answer if you don't have the rule completely memorized. It's good that the attorney advised the client to have that outside representation, but the lawyer didn't go out of his way to say, we can't enter into this agreement unless you are independently represented. And we know the client was not independently represented, and yet the lawyer still agreed to this arrangement. So A is wrong. B says yes, because there is sufficient consideration for the agreement. To me, answer choice B almost sounds like an answer to a contracts question, and this is not a contracts test. Consideration is not at issue here. What's at issue is the lawyer's ability to ethically, prospectively limit liability. It's wrong. C says no, because the attorney used a form he printed from the internet. C misses the point because the problem is that this lawyer is attempting to limit his malpractice liability prospectively, which is not allowed under these facts. The issue in this question is not necessarily where he got the form from. D says no, because the attorney is attempting to limit his liability for malpractice. And D is exactly what we're looking for. So D is the best answer. Question 3. The facts state, an attorney represented a plaintiff in a complicated medical malpractice case. The attorney was having a difficult time proving part of her case and was unsure how to proceed with it. The attorney asked another associate at the firm for assistance. The associate had a lot of experience with medical malpractice cases. The attorney identified the client by name and described the entire case to the associate. The associate was able to adequately assist the attorney. The client was not charged more for this associate's assistance. Was it proper for the attorney to consult with her associate? The rule being tested here is whether or not a lawyer can share in client information with other lawyers in their firm. And the answer is yes. Lawyers can work and lean on other lawyers in their law firm to help their clients. And in fact, that's why most clients like hiring big firms that are high-powered with lots of attorneys, because they know that there's a lot of people at that firm to help on their case, to potentially get that outcome that they desire. So it's not an issue that this lawyer turned to her associate and described the case or told the client's name to this associate. Now, had the client given specific instructions that no one else was supposed to handle the case or that certain people weren't supposed to know about the case or handle the case, then that's a different story. But none of those facts are present here. So revisiting the call to question, it says, was it proper for the attorney to consult with her associate? And the answer to this question is yes, because lawyers that work in the same firm can work together, and that's what makes this okay. Again, this is not an instance where the lawyer is reaching outside of her firm, giving up confidential information without the client's consent. So let's look at our answer choices. A says no, because the attorney told the associate the name of the client. Well, A is wrong. It doesn't matter that the lawyer disclosed this specific information to her associate. In theory, the associate had access to it anyways. They work at the same firm. So A is wrong. B says no, if the client's consent was not previously obtained. And as I mentioned, client consent in this instance is not required. So B is wrong. C says yes, because the attorney and her associate work at the same firm. C looks pretty good. This is why the lawyer can rely on her associates. So let's hold on to that choice. D says yes, but only if the client was notified of the associate's assistance in the matter. And D is wrong, because again, this is not a situation where the lawyer is going outside of his or her firm and giving up confidential information to those outside people to get help. Again, this is all staying in-house in the same law firm, so we do not need consent. We do not need notification. So D is wrong, making C the best answer in response to this question.